Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and it's great to have you with us today. We're going to be talking about repair requests and habitability claims, and get this straight here a little bit. Um, anyway, so thank you so much for being a member with us. AOA is really dedicated to your real estate success, and we hope that we can bring you information that will help you and save you from spending a fortune over a mistake over something that you didn't know. And man, we've been really speaking with a lot, engaging with a lot of the LA City Council members before, leading up to yesterday. And yesterday, a lot of you showed up, which was awesome, and that was so needed. And anyway, it didn't turn out the way we wanted to, but we're just going to keep pushing. And I've really, um, yeah, really just we got to up the effort that much more. So getting into this, we're going to have several events that are coming up here in the next week. On the 18th, we're going to be in Fremont, and it's going to be a legislative update for 2026. Plus, we'll have a tax specialist unpacking the big beautiful bill. And in Santa Clara, we're going to do that on the 19th. On the 20th in Sherman Oaks, we're going to cover security deposits, and there'll be a DST seminar. And then on the 20th in San Diego, same day, we'll have avoiding procedural mistakes in eviction actions locally there. And also just want to mention that AOA is going to have the AOA, the Political Action Committee luncheon on January 10th. And that's going to be at a Marriott in Torrance. And let's see, we got people in the waiting room. Let's get these people taken care of. Admit everybody. Okay, I think we got them admitted. Right. Okay. And yeah, so we're going to have that packed luncheon. And the district attorney for Los Angeles, Nathan Hochman, will be the special guest speaker, and he'll speak for about 20 minutes. And we're just going to be able to connect and see what we can do to continue to advocate for you and for ourselves with all this that's going on. And anyway, so real thankful for SNS Law Group. I looked at their Google business profile today. They have 23 five-star reviews, and this is a company that's focused on real estate and business law. Really sharp group of people over there. And our special guest today is a co-founder and partner at SNS Law Group. And before earning his Juris Doctorate and co-creating SNS Law Group, he he found a passion for real estate management and development. He has managed over 100 million in assets for different clients. And so we have attorney Bijan Shakibkoo with us. And so I just want to turn things over to you, my friend.
Especially when there's these hot topics, when
Yes.
the habitability issues and it's overwhelming about how many calls I get, how many clients I am representing for habitability issues, and we're going to get into the crux of it, and we're going to talk about what landlords' obligations are, the pitfalls to be able to avoid liability, and how to make sure that you are secured. Let me go ahead and share my screen here. All right.
There we go.
Beautiful. Okay, so everyone, my name is Bijan Shakibkoo. Just like what Jeff mentioned earlier, our primary practice of law is real estate and business litigation. Under that falls a lot of landlord-tenant disputes. I represent primary landlords and every type of actions, and a lot of them are going to be habitability. So we're going to jump into that, and we do also process many evictions a month as well over here. Today's agenda, we're going to be jumping into landlord's obligations, the common pitfalls leading to liability. And then the goals of this session is to understand habitability standards and the best practices for handling repair requests. And on top of the most important, way to get around all this is reducing your exposure to tenant claims and lawsuits. So this is the legal framework. These are the most common, whenever any landlord is getting any type of lawsuit filed against them, these are the typical causes of actions that get brought up. Whether if it's the breach of the California Civil Code, which is between 1941 through 1942.5, the Health and Safety Code, and then also your traditional implied warranty of habitability. Now, I really encourage landlords to be able to look up these laws and get an understanding of what is considered a breach in habitability, meaning whether if the unit or the home is in despair, what causes it and what is required and what renders it in an uninhabitable condition, which is the two main things, which is under the Civil Code and under the Health and Safety Code. The implied warranty of habitability, and these are slapped onto a lot of lawsuits where, anytime a tenant who signs a lease agreement or who, takes possession of a property and that landlord-tenant relationship is created, there's an implied warranty of habitability that the landlord will provide a habitable premises to the tenant. And if the premises is not rendered habitable, then it will be, it will breach this implied warranty. And a lot of this stuff that we're going to be discussing today is very elementary for landlords because obviously it's important to maintain the premises, making sure that there's no waterproofing issues, plumbing issues, heating, electricity, sanitation, and structural safety. So one of the most common violations that I see anytime a client retains me is water leaks that do end up leading into mold because mold is connected with water. Pest infestations of broken heaters or no hot water, faulty wiring or lighting, unsafe stairs and handrails, and sewage and drainage issues, which that's very common in a lot of older apartment buildings in Los Angeles where there's issues with water being backed up, the sewer lines get clogged, and which causes a bunch of sitting water, whether if it's in the sink or in the bathtub or in the kitchen sink. So those are really important to be able to address, and this is a lot of the issues that I see that come across my office. How to handle repair requests. So, when you're dealing with repair requests with tenants, the most important thing that I try to emphasize that landlords be able to address to their tenants is if there's any repair requests that need to be made, that needs to be done in writing. Therefore, it's documented, it's time-stamped, and then it will also be able to benefit you in the event that the tenant tries to bring up claims that they were unable to reach the landlord, or the landlord didn't do anything about it, and the condition of the premises was like this for some time now. So make sure that the repair requests are given in writing, whether if it's an email or if it's a form that you give them, or if it's even a text message. And then, to addition to that, acknowledge it promptly, just letting them know that you'll address the issue. And then once you are going to address the issue, make sure you're documenting everything. You're taking photos of stuff. You're keeping logs. You're retaining all the communications between you and your tenant, because this really benefits you in the event if something comes down the line, whether if it's a complaint coming down from the LAHD violation, or if you're, God forbid, if you're getting a lawsuit that's coming down, you have all these documented to be able to defend yourself. In addition to that, obviously investigate it quickly, get the proper vendors out there, and make sure that it's addressed within a reasonable amount of time. Now, the most important thing here is there's case law that reads that depending on the circumstances, if the condition of the premises have been lasted from longer than 30 days, meaning they told you about it, there's nothing done in over 30 days, then that opens up the door to liability. That opens up the door to the breach of implied warranty of habitability and those other civil codes that I referenced earlier. Obviously, for example, if a whole roof collapse, it takes time to be able to, repair it. But if we're talking about a leak that occurred in a kitchen or, smaller stuff, and they're not being handled within a reasonable amount of time, preferably within those 30 days, then that opens up the door to liability. So, and in addition to that, once the work is completed, make sure you take photos and you document it. And you confirm the completion with the tenant in writing, pretty much memorializing with them saying, hey, you addressed this issue to us on so-and-so date. We brought out the proper individuals to be able to fix that issue. And now the issue has been resolved. And just make sure that's in writing and it's also documented. Again, I kind of hit the nail on its head, but documentation and record keeping is the most important thing. In addition to that, why it's important is because it's a very strong defense against habitability claims. So that's why it's important to maintain a repair log, save your invoices, your work orders, and take photos of everything. Discussing tenants' rights to repair and deduct. This happens very often where a tenant will claim, or even if they did notify the landlord of a specific condition. Let's just say it's a leaking faucet and the faucet wasn't getting repaired. Then a lot of times what I've seen is the tenant has a right to do that as well, to be able to make the repair and deduct it if the landlord fails to act timely. Now, what is considered timely? Obviously, it's a very objective view, and it really depends on the circumstances and what kind of an issue it is. So just keep in mind, and what I've seen in the past before, a lot of times this is beneficial for an eviction action, where it kind of coincides hand in hand, where a tenant will go ahead without even giving notice to the landlord of the condition or the repair request. They go ahead and make those repair themselves with unlicensed individuals, people who are not capable of even making those repairs. And that is a breach of the lease agreement. A lot of lease agreements state, and I'm sure AOA's lease agreement has it in there too, that any modifications or if there's any work done in the unit without the landlord's consent, that's a breach. So you could actually use that against the tenant and say, hey, you never had authorization to be able to make these repairs. And the way that it was made, it wasn't with the proper professionals, and actually opens up the door to liability as well. Not only for the tenant, but also for the landlord, because if the tenant is going ahead and, for example, if they want to make repairs to electrical panel, and if they do that without a licensed electrician, that's a big problem. And that's why it's very important to not just let your tenants go ahead and make repairs on their own, because you don't know how they're doing it or whether if they're doing it in the correct manner. So for example, if you have a 10-unit apartment building and they go ahead and start messing with electrical and something happens, who do you think that the other tenants or even the city is going to go after? They're not interested in the tenant. They're more interested in the landlord. So just make sure if the tenant is doing any modifications within the unit, let's just say they're making repairs, make sure that's run by you. And if it's not, address it with the tenant. Responding to habitability claims. So this is similar to responding to a repair request, right? You have to get in there, inspect the property, whatever the issue is, see what is going on, document it, make sure, whatever the claims are the tenant is making is true. And if it's not true, make sure you put it in writing saying, hey, we came out here, we inspected the property on so-and-so date. The conditions that you are referencing is not the actual conditions that are happening in there. So as long as you have that, documented, that's important. And then in addition to that, especially, if it's an RSO building or, in Los Angeles, depending on what the condition is, offering temporary accommodations is important. And the reason why is because, let's just say they claim that there's asbestos, or if there's mold in the unit and they're getting sick. At that point, I would recommend, possibly relocating the tenant temporarily until the issue is resolved, and then bringing them back in that unit. Because every single day that that unit is considered hazardous, the tenants is going to try to rack up their damages and claim that the landlord didn't do anything about it. They didn't relocate me. They were supposed to relocate me. So that's important to know. If they're bringing up habitability claims, and if depending on whatever the condition is, relocation is something that should be entertained. In addition to that, avoiding retaliation. So if a tenant is claiming that there's habitability issues and they've reached out to government officials, meaning Los Angeles Housing Department or the Health Department, and then you in turn, let's just say, hit them with a rent increase. Well, that looks like it's retaliatory, right? They're making these complaints, and then in turn, they get slammed with a rent increase. Make sure you don't do that. Even if you hit them with a 3-day notice for non-payment of rent, if they're not paying their rent, make sure that if there's any pending violations going on with any governmental agencies, or if there's any pending repair requests that need to be done, make sure all of that's out of the way before you issue any rent increases or before you issue any notices to the tenant. And I really hit the nail on its head on that, because a lot of times I have clients who come to me, and they tell me that the tenant hasn't paid rent. And I tell them, okay, I run through a list of questions with them. And one of them is there any pending violations with any governmental agencies? Has the tenant claimed that they're not paying the rent because of a habitability issue? And they may say yes. And if they do say yes, at that point, I would tell them, make sure you get that resolved, because I'm not going to go ahead and issue a 3-day notice before that issue is resolved, because they're going to use that as a defense towards the eviction action. So just make sure that everything is out of the way before you commence any eviction with the tenant. And then to that account, if, for example, a lawsuit comes down the line, or if you get a demand letter from an attorney, communicate with counsel. Get an attorney who practices this type of law and could walk you through the proper ways to get around this. A lot of times with habitability claims that tenants make, what I've seen the most is, number one, they use it as a crutch to avoid to pay the rent. So they can't afford the rent anymore, and they're trying to get around how to not pay it, so they would start raising habitability issues. So I would be on the lookout for that. And then number two, these attorneys, when they send these demand letters, they're looking for the big pockets. They're looking for money at the end of the day. And in the demand letter, even if it's a frivolous claim, they would put in there that, tender this to your insurance company, or provide me with your insurance information. Now, as we know, in California, as a property owner, it's already hard enough to obtain insurance. And in the event, if something like this was to be tendered to an insurance company, there is a chance where the insurance company will fail to be able to pick up the claim due to whether if it's not covered under the policy, or if they do pick it up, there's a chance that your premiums will go up, or your policy will be canceled outright. And the insurance company they're in the game of just denying any claim they possibly can. So what I would say is, and a lot of the attorneys, that's what they're looking for the insurance, right? So even if it's not a legitimate habitability claim, what I do is, for example, if someone was to call my office, I would immediately reach out to that attorney. And depending on it really depends on what the facts are, right? I mean, if these are frivolous claims, and I know the attorney is just looking for some money, I would tell them that insurance is not going to be provided to you. And a lot of the times, they'll just, after the demand letter is sent, they won't come back. Some attorneys, they like to push the envelope and file a lawsuit. But when they see that there is private counsel that have been retained, it really deters them, because now they're seeing that the insurance company has not stepped in, and they're going to have to fight tooth and nail to get something. In addition to that, if you do ever tender your your claim to an insurance company, I always recommend for even for the claimant to be able to be represented by personal counsel as well, because the insurance company is not in the game of litigating cases. They're in the game of settling. And in addition to that, the attorneys that the insurance company hire, their knowledge in local ordinances, for example, the RSO and landlord-tenant disputes is very limited. They're just there just to be able to process a civil litigation. So, I'll give you an example. A lot of the times when if a habitability lawsuit comes down the line, you tender it to your insurance company and it gets to some sort of a settlement. If you don't have an attorney who knows this type of law representing you, a lot of times the insurance company would just pay out to the tenant, but the tenant will still be in possession. And no landlord wants to have a tenant who is still living on the property that sued them before, right? So what I do, when you have counsel behind you, you actually tell them a part of the settlement terms, if it does go to a mediation, the settlement does happen, it has to require the tenant to vacate. Insurance defense counsel, they don't think about that type of stuff. They just want to get in and out of the claim quickly. So we'll jump in a little bit into insurance. As far as limiting liability, making sure that you're covered, the one thing I recommend is if you're holding the property in your individual name, like your natural name, I would recommend putting it into an LLC or some sort of a corporation to limit your liability, because that way they can't come after you personally. In addition to that, insurance is very important to have on your property. So, having and not only that, there is property insurance, but there is specific policies that you could get for habitability claims. So in the event that, if a habitability lawsuit comes down the pipeline, the insurance company is going to have to represent you in that case. So just make sure that, you obtain insurance coverage, that the policy is a landlord-tenant policy. And then in addition to that, when you are reviewing the landlord-tenant policy, a lot of cases that I'm getting are for mold cases. And a lot of these policies, there's a mold exclusion. So if you are obtaining new insurance and you're getting that landlord-tenant policy, make sure there is mold included in there and habitability claims in there as well. So, these are the main lawsuits that are being filed for. So, the whole point of paying for insurance is to make sure they cover you, right? So make sure you have those claims in there so they could be able to represent you in the event something happens. And then if you really, really want to just make sure that you're completely covered, you get a, look into umbrella coverage, for the property. That'll be an additional insurance to umbrella the whole property. And this could be pricey, especially in California. So it's definitely something to consider, but these are the ways that you can really be able to limit that liability. Lease drafting and the best practice. So this is another way that liability can be limited, is providing the tenant with mold disclosures and waiver clauses. Another really important thing to include is shortening the statute of limitation on tenant claims. So a lot of lease agreements don't state that. I like including that in lease agreements when I draft them for my clients, and I limit them, to 1 year. Because if you leave it open-ended, the statute of limitations could be up to 4 years. And a lot of these lawsuits happen after the tenant vacate. A year down the line or 2 years down the line, 3 years down the line, all of a sudden a landlord gets slapped with a lawsuit from a tenant that was in possession years ago. So it's always important to include that provision in your lease agreements. That way, as another avenue, you can be able to limit your liability. And then also, clearly defining maintenance obligations, which is pretty much stating to them that if you ever want to make a repair request, this is the proper steps to make it, so everybody's on the same page, and they don't just send random text messages. They have to go through a proper procedure for any repair request. And this is a little bit a shot in the dark, but it's a deterrent more than enforceability. And that's the indemnity and a hold harmless provision in the lease agreement. Now, a lot of attorneys who are opposing it, they will say it's unenforceable. But between a landlord and a tenant, when they see that clause in there of the indemnification, the hold harmless provision, it deters them because they'll read it and say, oh, you know what, maybe there's nothing I can possibly do because I see this indemnity and hold harmless clause. So, I'm not going to really pursue this. Now, again, attorneys find their ways to get around it. Is it fully enforceable? Probably not, but it could be considered a deterrent. Handling difficult tenants. Now, this is a very loaded topic, dealing with difficult tenants. Again, it really just comes down to just, being professional, documenting everything and making sure all the communications are done in writing. That way, there is never a he said, she said discussion going on. Everything's in writing. And obviously showing your good faith as a landlord, trying to be able to, make the tenant's life pleasant, making sure that, any repair requests are being made, they're being made promptly. Obviously, avoid any verbal confrontations with them because in Los Angeles specifically, there is tenant harassment ordinances and statutes that protect them, and they love to hang their hat on that. So any confrontation is always better to avoid. And then, goes to delaying any repair, never delay any repair requests. And then again, if it's really getting out of hand and it's something that you feel like, it could lead to litigation and, it's just something you can't be able to handle, speak to counsel. And a lot of attorneys, just like myself, I walk through my clients on how to properly respond to tenants, what to do if an issue comes up with habitability or if they're threatening lawsuits, and we work around that. So, the key takeaways for this, presentation is to respond promptly, document everything thoroughly, and also use a licensed professional. For example, if the tenant is making, complaints about mold, don't go send a repairman over there and just spray bleach on the wall and wipe it down. You need to be able, depending on obviously the circumstances and how extensive the mold is, a lot of defenses that tenants tend to raise, with mold is, you didn't hire the proper professional to do it. They weren't certified in handling, toxic substances like mold. And therefore, spraying a bleach on the wall was insufficient. I'm still having these health issues. And then obviously staying compliant with the civil code, which we mentioned earlier, and make sure all communications are clear with you and your tenant. Other than that, I'm here to take any questions and be happy to answer them.
Awesome. Great. Thank you so much. And yeah, we got a bunch of people on the call, and we can, if you raise your hand, we'll get to you. And we have some questions here in the Zoom chat. So I'll go to these. And Jack, prior tenant is suing for deposit since we had to spend it on removing dog ESA odor, urine soaked into carpet pad, hairs, etc. All laws were followed in notifications and documentations. And should he get counsel on this is his question.
Well, I mean, it really depends on the circumstances, right? What the amount of the dispute is. A lot of these, what I've seen recently, a lot of these security deposit disputes are handled in small claims courts. And, obviously a lot of attorneys don't represent clients in small claims courts. So, if we're talking about, damages in excess of, $10,000 running up to 20K, 25K, 50K, at that point, I would recommend retaining counsel. But I really want to make it an emphasis here that and then it goes back to where your property is situated. I tell my clients all the time, if you're going to spend a bunch of money on me to chase after something that's not there, for example, if you want to go and sue the tenant for the damages that were excess in the security deposit, you just got to be prepared to see, what does the tenant have? Did they have anything to their name? Are they judgment proof? Do they own any property, any assets? Are they working? A lot of the times they don't have nothing. So at the end of the day, you're going to spend tons of money on an attorney and you're not even going to get anything back. So it's important to just keep that in mind. If we're talking about, a multi-million-dollar house in Beverly Hills and that the individual, has assets, yeah, it's a different discussion that we could have. But, majority of the time, that's not the case.
Great. Yeah, and I think we'll try to get, there it is. Look at that. Someone was asking, hey, could we get that split screen? And boom, right?
Yeah, like
Right, right away, there it is. So there's his contact information. You can see that 424-220-2052. You guys are on the west side, but what area do you service?
we handle all over Southern California.
Yeah, so you go up to Ventura?
We'll go up to Ventura. Yep.
Okay. And
Handle
in
the-
as far south as Orange County?
I've been as far south as San Diego. So
Okay, San Diego's kind of a different beast.
it
So,
is, it is, but we've handled cases there. But yeah,
all
primarily,
right.
anything Southern California
All
will
right. Okay, there you have it. Okay. And here's a question in the chat. Who decides where they are located? I think that was in the context of something you were talking about. You got an idea on what she might be asking?
I think maybe are they referencing the relocation? Or was
Yeah, I bet you. Yeah.
Yeah, yeah. So possibly relocation. So it comes down, it depends on what kind of a property you have. So, if you have a single family home, obviously, your lease agreement is really going to govern whether if the tenant should be relocated or not. And it depends on the circumstances. But a lot of the times where I see that tenants are entitled to relocation is under RSO buildings. So anything that's rent controlled, and the tenant needs to be relocated depending on the condition. Obviously, you have to go through specific issues like tenant habitability plans and go through the proper steps there where you have to either, whether if it's through a per diem agreement where you agree to pay the tenant a monthly, whatever the value of the daily rate is of the rent, you pay them and they go somewhere else and live for that time being. Or if you have another unit that's available, you could provide that to them until the issue is resolved and then bringing it back in.
Now, I'm sure you've never seen this one before, but what if a tenant does not bring the issue up until after the 3-day notice has been served and contacts the city without your knowledge? If you never saw that one before, right?
Yeah, not in my life, Jeff.
If you pause the eviction to complete the if you pause the eviction to complete the repairs, do you have to start the process all over?
No, at that point, no, it's too late. And it's funny because, when me and Jeff were laughing about it, because this happens all the time
Yeah.
where, the eviction is processed and all of a sudden all these issues came out of the woodworks. No, the duty of a landlord to be able to act is once you are put on notice of it. So once the tenant has put you on notice of it, then you have to act. But if we're talking about in the context of a litigation and eviction that's been filed, at that point, it's too late because if they didn't bring it up to you before the eviction was filed, and now they're just bringing it in to secure some sort of defense, it's moot.
Great. Okay, how much liability insurance would you suggest?
I that's a good question, and that goes back to what kind of a property you have. What I would suggest is getting the highest policy you can. So the more coverage you have, the better you're secured. And that just goes to not only habitability issues. God forbid if somebody gets hurt on the property, a slip and fall, one of the railings break off and somebody falls off a balcony, something. It's always better to have the highest amount to cover you.
Right. And I know I'm trying to remember, like we have that on the 100Q, we have that on there. Let's see. Liability coverage amount 100,000, 250, 500,000. So those are different levels that are pretty standard.
Yeah.
That's on our 100Q form. That's on there. And then there could be additional liability coverage for the EV charger, and that could be 10 times annual rent. So those are some things just on the form there that you could look at. Right. Please text your information for contact. Like we already got it up there, so I think you're taken care of, Frank. Are you accepting new clients and management companies?
Yes, we are. We're
Okay.
accepting new clients. It's funny, a lot of our clients are management companies that we represent. So we are always accepting new.
Mhm. And relocation, it kind of depends on what it is. They're asking about termites, so it would really depend on the type of. Yeah, do you want to address that? What if it's termites? Do you need to relocate?
Well, termites are interesting because a lot of the times to be able to address termite issues, they require the whole building to be tented. So obviously, yes, relocation should be provided. And it's not that it's mandatory that a landlord needs to do that. It also shows your good faith as a landlord, just in case if they try to make any, claims down the line, you could say, hey, you know what? We relocated them, we offered relocation, we told them that we'll put them in another unit, or we'll pay them for the days that they're not going to be able to have the unit. That it shows that you're doing your best faith effort to be able to accommodate to the tenant.
Great. Okay. Can you require tenants to have the renter's insurance? That's something, it's included on the AOA lease. You can require it, but you can't evict for it, could you?
No, not in Los Angeles, at least. No. So I would require it. It's important for them to have that. Is it, a complete defense for a landlord? No. I've seen, attorneys get around that all the time. But yes, it's important to include that in your lease agreement.
Okay, question here from Maya. Do you have a referral for a Bay Area for Oakland attorney? And I want to say Mike Shepard. Mike Shepard's great attorney that's up there. Richard Beckman, those are two. And what you can do if you go to aoausa.com, the website, there's a contractors and vendors tab. You click on that and you just type in the word evictions, and that's like a category that'll pop up, and it will populate if you allow our website to know your address, then, or just your location. It's not going to ask you for anything. Then it will populate according to what's closest to you. And okay, we got Linda with a hand raised. So I can unmute her. Let me get on the right view here and try to unmute you. Ask to unmute. There we go. Oh, one more time. Let's try it. Hey guys, can you try to unmute her? There. Ask.
So all right, the hosts are not allowing me to.
Okay, there we go. I can hear you.
Okay,
great.
Thank you so much. I have a duplex, and one of the tenants has been there since 1981. Over the years, she has always had a dog. The building has a fenced backyard, large fenced backyard. This dog keeps finding places to dig under the fence and escape, either into the neighbor's yard next door or into the street. Both the tenant and the neighbor, with whom I am on very good terms, seems to think that it's somehow my responsibility to keep filling up these holes that the dog keeps digging to get out of the yard. So my question is, what is my responsibility both to the neighbors and to the tenant to keep this dog secured in the yard?
Well, that's a very good question. Is the property located where's the property located?
Oakland.
In Oakland?
Yes.
Okay. Well, at the end of the day, you have to, take a step back, and this is not your dog, right?
It's not my dog, no.
The tenant is responsible for their animal.
That was my instinct. Thank you.
Yeah. So if the dog is running away, obviously it's not in your control whether if the dog runs away or not. It really comes down to, whether the tenant is handling their own pet or not. I would say that the condition of the property, if you're saying that the dog is escaping from the hole, then there could be an argument raised that the dog could escape from, another area of the property. And
well, that's the thing. Every time I fill up a hole, with cinder blocks or riprap rocks, she finds another place to dig under.
Yeah.
So
I would not be too concerned. At the end of the day, the way that I view it is that it's the tenant's responsibility.
Thank you very, very much. I appreciate that.
Yeah.
All right. And if you guys have any more questions in the Zoom, raise your hand. And I love being able to do that. If you want to show video, great. If not, just having the audio is wonderful. And we have some questions here. Bijan, you have a little more time for us?
Yeah. I got some time.
Great.
Yeah.
So this question is a little off topic, but let's just hit it only because I know a lot of people have it. I gave a 60-day notice of a 6% increase. This is LARSO. As of January 1st, so the rent increases for January 1st, 2026, and I plan to give a 60-day increase of rent as a January 15th to a second house. Oh, okay, so it's a house. So maybe it's not RSO.
Yeah. So,
Bottom line, when does the 4% increase limit go into effect?
well, we don't know that just yet because it has not, from my understanding, the vote has not been finalized. But they're claiming that it would, if it was to go into effect, it would be sometime in February of 2026.
Right, because that was like when COVID ended, that was when they allowed the 4%. And so yeah, it seems like that would be right. Okay. Tom on YouTube, what about a tenant who caused a sewer stoppage?
Oh,
Plugged up.
that's interesting. Yeah, I love it's funny because I've done a couple of those. Um, I'm a little bit, I'm not like, I would put it this way, I'm not like your typical attorney. I like to think outside the box here. So, when it comes to sewer line, it's very hard to be able to determine, which unit in the building is actually causing the clog, right? And it depends on how big of the building it is. What I've done in the past is I've directed my client to go ahead and issue a notice of inspection for all of the units in the property. And for example, let's say it's flushing of baby wipes. Okay. Um, and again, this is just more of an aggressive approach where we'll issue a notice of inspection of all the units in the property. We'll get in there, and then we'll see, take a look at all within the unit. And if we see, for example, baby wipes sitting on top of the toilet, then there's a presumption that this individual is flushing it down the toilet, right? And you could always come back and, either whether if it's through a notice or through a letter, letting them know that, from our investigation and from our inspection, we've noticed that there was, for example, baby wipes sitting on our toilet, and we advise all tenants not to flush down baby wipes. And if you do, then according to your lease agreement, whatever provisions that we want to pull, we could use that to enforce it.
Okay, great. And we have a couple people. Jim, man, I thank you so much. Let's see if we can get you unmuted and go ahead and try to talk. Let's see if it, there
Can you
you
hear
go.
me okay?
Yeah, I can hear you great. Thank you.
Super. So, question on this shortening the statute of limitation on claims.
Mhm.
Is that actually enforceable?
It is. It is. I've done it before. Now, obviously, there has to be a reasonableness to it, right? So if you're saying that if you want to shorten the statute of limitation to 3 months or to 6 months, I would say, there's an argument that it could be unenforceable, but a year is sufficient. So if you want to limit it to a year, I've used that before as defenses, and they've worked many times in the past
A year beginning when?
from the termination of the lease. So,
Oh,
yeah. So let's just say
okay.
that vacated, they'll have up to a year to bring that claim.
Man, I'm gonna have
And
to
where can
add
I
that.
get?
I like that. I'm gonna have to add that to
Oh
our.
yeah, I love it. Yeah, and this is where, obviously, not your average eviction attorney would think of these things. And because my background of, complex real estate litigation, these are the things that we think about, right? So it comes back to traditional contract law, and that's the way that you could be able to implement it. So yeah, I've done it before, and it's been successful.
How
Great.
can I get a copy of that clause?
There's that
Call my
number right
office.
there, right? 424-220-2052. I did put it in the chat, and there we go. So, man, Al, love you. You're in San Diego, I know. Talk to us. Al, go. There we go. Go for it, Al.
Can you guys think, hey, hi, my name is Al Del Mastro. Yeah, I mean, me and Jeff has worked on fighting our city council quite a bit because of the unfair practices that keep continuing. But a couple of things that I've been concerned about is that our city council in San Diego seems like they're licking their chops, wanting to put punitive damages in, almost like if a small mom and pop gives somebody a bad form or an old form, they want to sue old ladies over it. That's a big concern for me.
So was there a question, Al, or?
Yeah, the punitive damage part of it. Have you seen much of that going on? Where they're going above anything that, they want to punish the landlord with punitive damages, especially the small mom and pop.
Well, I mean, it's, it's the cities don't surprise me with the type of statutes and laws that they pass, right? At the end of the day, if you're asking me whether if it's enforceable that a city is attaching a punitive damages to, small mom and pops, obviously I'll have to take a look at that ordinance or wherever the law reads. But, unfortunately, it's an upward battle dealing with cities and government officials. So unless if you have deep pockets, then I would say, just figure out ways to get around it, right? It's not, dealing with city council is always an uphill battle with them because they have unlimited funds and resources to be able to defend themselves.
And then real quick, sir, there's an issue. I always wondered if somebody gave me notice to move and I rented the place while they lived, the people haven't left yet. What would happen if I came to the situation where the people, now that they've given me written notice to move and I have somebody moving in and they refuse to move? What would I do in that situation?
It depends what kind of a property it is. So for example, let's just say in the city of Los Angeles here, if it's an RSO building and the tenant states that, they're going to move and then they decide not to, that's not a basis that you could use in order to enforce an eviction action.
So for San Diego TPO, it may be it might vary a little bit from the one that's up here in Los Angeles. So that might be a good question for Franco or Victoria.
Probably, yeah.
Yeah. Okay, here's another one. Thank you, Al. I love that. Al is a fighter, and yes, he is all over them. And if everybody were like Al, let me tell you, there wouldn't be rent control. If we had 100% like him, I'm telling you, Al, I love you, my friend. Okay, here we go, Victoria. We have a duplex on a parcel shared with a house in the front. Above tenant signed rental month to month with my deceased stepfather, who is a landlord. It was to be a 2-person MAC occupancy. They now have 3 children. I presented a summary and follow-up report, property inspection and unit condition for all his units, total of 4. This particular tenant has thrashed the apartment beyond normal wear and tear and use it as a storage unit, no storage provided. We are trying to get them to clean it up and clean up the appliances. They are so damaged and overused. We have asked them to repair and replace it themselves. We tried to do a 60-day notice to quit and take over for the family. So there's the ordeal.
Yeah, I would say from obviously I have to get a little bit more information, but just based off of this synopsis, I would say that it sounds ripe for an eviction action. Now, by ripe, I mean, obviously we have to, depending on the documentation that we have, whether we have photos of the damage that was caused, I would link that to the provisions of the lease agreement and then issue a 3-day notice to the tenant for that. Now, obviously, it seems like the landlord in this situation is going for the lower hanging fruit and would want to be able to just go in there and take possession of the property either for themselves or a family member. That's always an option that you could take. But if the damage is really excessive and you have documentation of it, and if the tenant's failing to be able to fix it, then we could always use provisions of the lease to enforce an eviction action.
Yeah. Sounds like it's need to make a call.
Yeah.
All right.
Give me a call.
So people are asking, everybody's on that statute of limitations. So it can't really be an addendum unless they agree to sign it.
Yes. Yeah. So it has to be something that they're also acknowledging and signing to. So it's not something where you just issue to them and saying, hey, by the way, this is the statute of limitations. No,
Right.
it's something
That's
has to be contractual. So there's got to be a meeting of the minds, which means a signature on both ends.
Is it okay if we borrow that idea from you?
Please go ahead.
Okay, so
I'm
that's the
all,
highest compliment we could pay you, right?
yeah.
And guys, Bijan does look at, like, we have him review our stuff. He's part of a group of attorneys that we have look at our agreements and everything, and we're gearing up for 2026, and we got some changes to make. All right, okay, I was told that if your home is in an LLC, you cannot represent yourself in court. Is that correct?
That is true. Yeah, a corporation cannot be self-represented, so you'll need an attorney to represent you.
Okay, property in Montebello, Section 8 tenant. The tenant is now a hoarder. What can I do with him? Can I evict?
Okay, so hoarder is a very loaded. A lot of people use hoarding, and sometimes it doesn't meet the standard of hoarding. Like for example, I've done cases when there's hoarding where there's either trash or whatever. There's objects going to the ceiling of the unit, or you can't even walk in to the unit or the home because there's so much stuff. When it goes to that extent where it becomes a fire hazard, meaning, in an event of emergency where an individual can't be able to properly escape or vacate, then I would say that would be ripe enough to be able to, address it with the tenant and issue a notice. Now, whether if there's a lease agreement or not, that's where it becomes more of the question because with the hoarding cases, I always like lease agreements that I could pinpoint provisions to. Now, if I have to go outside the box and bring in, city ordinance violations for, building and safety, then we could always include those. But the lease agreement is always an easier route to take. So I would suggest this individual to call my office.
Okay, great. And we haven't even gotten to the ones on YouTube. So can we do a few on YouTube? It's
Sure.
12:52, maybe.
Yeah, I'll have until 1 o'clock. So
Okay, so we'll try to do a speed round starting now.
Spitfire. That's what it is.
Okay, here we go. This one's really long, so I'm going to skip it. Actually, I won't. Okay. What if tenants are collaborating with each other and causing leaks? We've had numerous leaks in building with 4 tenants within a week. They are mainly under the kitchen faucet and claiming tenant above. But one incident, we have a tenant unscrew their shower head where it shot over to the kitchen. We do most of the repairs ourselves as we've had issues with property management. They are loosening the plumbing. They've been there for 8+ years. It all started with one tenant saying that there's a leak under the sink. We get there and it's fine. Then they complain about roaches and holes in the walls that they put in themselves, saying structural. Can you also provide the difference between habitability versus normal wear and tear? I think that one's kind of a whole nother, that could be a whole
Yeah, that's a
seminar.
whole nother topic. What I would say is, with these type of circumstances, it's very important to get expert. As an attorney, we call it expert reports, which means that get a licensed professional plumber out there to write a report that could conclusively state that, whatever the issue that's happening, it's being done by the tenant's conduct. And if we could be able to establish that through through a plumber who is an expert, then I could use that for a basis to enforce whether if it's an eviction action or even a breach of the lease agreement. So I would say the best route to take is to get someone who's licensed that could be able to generate a report stating the cause of the issue. And that way we could be able to address it.
Gosh, they're gonna run up the bill on these guys. I feel for you. All right, on YouTube, can it be in a trust to avoid personal liability? And then what's an umbrella policy?
So the first question is, a trust can limit your liability. Obviously, it's not directly to your individual capacity. So yes, you could put it in a trust, and also there's tax benefits to that as well, including with LLCs too. To the second question, as a umbrella policy, so look at it like you have your traditional policy, your insurance coverage, And then you also have an umbrella that is, if it ever exceeds that, your umbrella policy will kick in to be able to cover you. And obviously there's different policies out there. I'm obviously not an insurance agent or have any expertise in insurance. So I would advise you to speak with an agent or someone who is in insurance to give you more of a better direction.
Yeah, we have an affiliate. It's Golden State Insurance, and so you could check our website for that one. And they've been, I'd say, more than 9 times out of 10, they're getting a better deal than anyone else because they're a broker and they're finding the best one. So give them a call, Golden State Insurance. Let them know we sent you, and that'll be awesome. Okay, my lender said if I change to an LLC, then they will recast the loan.
Yeah.
How does that work?
Yeah, that does happen a lot of the times where it will call the loan if you ever change title. Obviously, every loan is different, but yes, that is true. A lot of loans, depending on what kind of loan it is, it will call the loan because you're pretty much transferring title. It's no longer in your individual name, it's going to something else. So, depending on what kind of a loan you have, I would recommend speaking with your either it's a loan officer or whoever gave you the mortgage to see how you could get around that. I think a lot of the issues that I see with that happen is not that it will call the loan, but you won't be able to have title insurance. So your title policy would be at issue, and then you have to get another policy for the new ownership. So that's more of a question that you could ask, your loan officer or your whoever is handling your mortgage to see how you can get around that.
Mm-hmm. Okay, is the filing of the eviction a public notice?
Filing, so well, in Los Angeles, it's these are considered they're not publicly. So for example, if you ever put the individual's name or if you put a case number, it won't come up in the Los Angeles Superior Court. Now, a lot of landlords don't know this, unless, for example, if you're going through an eviction action, unless if you request the case to be unsealed, then it's sealed automatically. So if you're ever doing an eviction action, if there's any settlement or if there's a judgment, make sure you have your attorney request to the court for the records to be unsealed.
All right, we're coming right up here. Let's see. Okay, yeah, we covered that one. She's requesting repair of blinds and broken kitchen counters. Is this my responsibility? Am I only responsible for wear and tear? How to distinguish?
So what I would say is, especially with the kitchen counters, I've seen in the past where there was notices to comply from, for example, Los Angeles Housing Department for a cracked kitchen counter where they would require the landlord to be able to repair it. What I want to get across is, when it comes to things that are cosmetic, that really doesn't raise a habitability issue. It's more of things that interfere with the necessity of life and things that potentially can or are hazardous. So, for example, sometimes, there will be a cracked kitchen counter, and it could become a hazard where there's sharp objects or, the whole counter could collapse. And obviously that's something that needs to be repaired. But if we're talking about things that are cosmetic, it doesn't really raise to that level or to that issue of a habitability claim.
All right, tenant in older single-family home learned from our plumber that the unit has ceramic pipes to the street. Can they claim habitability to force the full replacement of plumbing for the older home?
No.
Yeah.
Unless if there's an issue with the plumbing, that's different. But if it's
Yeah.
whether if it's
Yeah.
copper or ceramic, that's not a raise of a habitability issue.
And I know we got a minute before. What I'll say, we do have exclusive videos that are in your AOA member account. Go under resources, go to videos. There's like a 3-part series done by one of the men that helped set up the systematic code enforcement program. So this is all it's California building code, but anyway, he really covers a lot of different things. So if you want to really understand habitability, what you should be checking, that is just a vital resource. And even though we did it a few years ago, there's nothing that's changed there, except now we have that new rule about the stove and the refrigerator being included in habitability. That's going to be coming up next year. Hey, everybody, thank you so much. And I know that we're leaving some questions on the table, and wish we could get to them all. Give Bijan a call. And anyway, oh, don't forget about your free supply to vitamin G. Go check our website, free supply of vitamin G. And I definitely took mine today. Hope you're able to take that. Happy Thanksgiving to all of you. Take care.
Thank you, Jeff.
The vitamin G